The Supreme Court's ruling on tariffs is deeply disappointing, and I'm ashamed of certain members of the court, absolutely ashamed, for not having the courage to do what's right for our country. I'd like to thank and congratulate Justices Thomas, Alito, and Kavanaugh for their strength and wisdom.
Okay, folks, sit down for this one, because what I'm about to walk you through is the single most consequential ruling of modern American history, and the mounting pressure to gut it before it destroys what's left of the rule of law. On July 1st, 2024, the United States Supreme Court ruled 6-3 in Trump versus United States that the President of the United States has absolute immunity from criminal prosecution for core constitutional powers and presumptive immunity for other official acts with no immunity for purely private conduct. Chief Justice John Roberts wrote the majority opinion while the three liberal justices Sonia Sotomayor, Elena Kagan, and Ketanji Brown Jackson dissented. Justice Sotomayor's dissent ended with words that have haunted American legal discourse ever since. "With fear for our democracy, I dissent." Civil liberties groups warned immediately that the ruling effectively gave presidents a blank check to commit crimes using official powers. Then Donald Trump went on to win the November 2024 election, and now the entire framework is being tested in real time. Constitutional scholars from across the spectrum are calling for it to be narrowed or overturned. Lower courts are struggling mightily to apply it. Federal judges are pushing back at every level. Can you believe this is where we are in 2026? Before we go any further, real quick, let's be honest. You can't really trust mainstream media anymore to give you the full picture without their own spin baked in. That's exactly why we built Pump Politics, to bring you real stories, real context, and no corporate spin at all. If you want to stay ahead of the headlines and get the unfiltered breakdown every single day, join our free newsletter. We'll send the news straight to your inbox without the noise. Just click the link in the description to join right now. And if you just want to support what we're doing here and be part of a community that actually cares about getting to the truth no matter where it leads, consider joining us as a member. All right, let's get back to the heart of this massive story because it deserves your full attention. The U.S. Supreme Court has ruled that Donald Trump has some immunity from prosecution for official actions taken while he was in the White House. The landmark decision is likely to delay or reshape his trial for interfering in the 2020 election. The former president described the decision as a big win for the country and for the presidency itself. Our North America editor Sarah Smith reports on the powerful implications. The Supreme Court has the final say on what presidents can and cannot do when it comes to legal accountability. Today's historic ruling means a president can never be prosecuted for anything that's part of their official duties as defined by the core constitutional powers. But they do not have immunity for purely non-official private acts. So what does this mean in practical terms for the criminal cases against Donald Trump, both past and potentially future ones? When he spoke to supporters on January 6, was he officially acting as the president, exercising his authority, or was he speaking purely as the losing candidate rallying his base? "We fight like hell, and if you don't fight like hell, you're not going to have a country anymore." The cheers from the crowd echoed that day, and now years later, the legal reverberations are still shaking the foundations of how we hold power accountable in this republic. Let me walk you through the specific three-tier framework first, because the structure of the ruling is what makes it so potentially dangerous and transformative for the balance of powers in our government. Tier 1 provides absolute immunity for the president's exercise of core constitutional powers, things like commanding the military as commander-in-chief, issuing pardons, recognizing foreign governments, nominating federal officials and judges, and other powers explicitly granted in Article 2 of the Constitution. The Supreme Court ruled these acts can never be the basis for criminal prosecution ever under any circumstances, period. End of story. No court can even examine them for criminality. Tier 2 offers presumptive immunity for other official acts that fall outside those core powers but still qualify as part of the president's official conduct. The president's official actions receive a presumption of immunity that prosecutors can theoretically rebut only by showing that the prosecution would not pose any dangers of intrusion on the authority and functions of the executive branch. That standard is written so high and so protective that legal scholars across the board have called it functionally absolute in practice, because proving no intrusion at all is an almost impossible bar to clear when dealing with the vast machinery of executive power. Tier 3 leaves no immunity whatsoever for purely private conduct that has nothing to do with official duties. The court did not spell out in detail which specific acts fall neatly into which tier, leaving that messy classification work to lower courts. Additionally, the court explicitly excluded prosecutors from using evidence of official acts to prove charges based on private conduct. This evidence exclusion rule adds another thick layer of protection, making it harder to connect the dots in complex investigations. Think carefully about what Justice Sotomayor warned in her powerful dissent, because her words cut straight to the heart of the fears many Americans have about unchecked power. Justice Sotomayor wrote that when the president uses his official powers in any way under the majority's reasoning, he now will be insulated from criminal prosecution. Orders the Navy SEAL Team 6 to assassinate a political rival, immune. Organizes a military coup to hold on to power after losing an election, immune. Takes a bribe in exchange for a pardon, immune. She repeated the word immune over and over like a chilling refrain to drive home the point. That is a sitting Supreme Court justice putting those extreme scenarios in writing in a published dissent listing exactly how the majority's framework could shield serious criminal conduct from any accountability. Sotomayor concluded that in every use of official power, the president is now a king above the law. The dissent warned that the ruling reshapes the institution of the presidency itself. It makes a mockery of the principle foundational to our Constitution and system of government that no man is above the law, king above the law. Those are the exact words a Supreme Court justice used to describe what the majority had created. Are you kidding me with how far this goes? Justice Ketanji Brown Jackson wrote separately to highlight even more brutal long-term warnings about the decision's impact. She wrote, looking beyond the fate of this particular prosecution, the long-term consequences of today's decision are stark. The court effectively creates a law-free zone around the president. A law-free zone. Those are her precise words from a Supreme Court opinion. Jackson continued, the risk of unconstrained official lawlessness has been removed only as to one player on our political stage, the president. Justice Elena Kagan joined both dissents, making it clear that all three liberal justices stood united in their alarm. Three Supreme Court justices publicly stated on the record that the majority's ruling created this law-free zone around presidential power. These dissents are not just partisan complaints thrown out for political points. They form part of the formal legal record warning the country that the ruling would produce exactly the kinds of presidential conduct we are now seeing play out in real time across 2025 and into 2026. Now let me tell you about the specific Trump conduct that is testing this framework right now, because this is where the abstract warnings from the dissents are colliding head-on with reality on the ground. President Trump has used the Department of Justice to pursue prosecutions against his political enemies, including former FBI Director James Comey and New York Attorney General Letitia James, through a hand-picked prosecutor named Lindsay Holligan. In a November 24, 2025 federal court ruling, Judge Cameron Curry found that President Trump and Attorney General Pam Bondi had circumvented vacancy laws to install Holligan in that role. Reporting from The Atlantic and other outlets highlighted comments from White House Chief of Staff Susie Wiles, who told Vanity Fair that the James case represented Trump's one retribution. It was a vindictive prosecution admitted by the president's own chief of staff. This kind of conduct is precisely what civil liberties groups warned the Trump versus United States immunity framework would enable the use of the DOJ as an official act twisted for personal vengeance rather than justice. Federal Judge James Boasberg in April 2025 found probable cause for criminal contempt against the administration over its defiance of his deportation order. That probable cause finding still stands, and the administration's defense leans heavily on the immunity framework established by the Supreme Court. Think about what the Trump versus United States remand procedure has produced in practice. The Supreme Court sent the original Trump January 6 federal case back to lower courts to sort out which acts were official versus private. The case wound its way through the federal system. Special counsel Jack Smith continued his work, but once Trump won the November 2024 election, Smith's prosecution was effectively foreclosed because federal policy generally precludes prosecuting a sitting president. The original federal case essentially died on the vine because of the election victory. The same immunity framework, designed to protect against politically motivated prosecutions, ended up shielding the very conduct the prosecution had been investigating. The Sotomayor and Jack dissents specifically warned that this exact pattern would emerge, where immunity becomes a shield not just for legitimate functions but for actions that skirt or break the law. Their warnings have been validated by the unfolding events in ways that even some original supporters of broad executive power now find concerning. The scholarly response since the 2024 ruling has been blistering and widespread. According to detailed analysis from Lawfare, the Trump versus United States decision goes beyond establishing a doctrine of presidential immunity. It declares the president effectively above the law in broad stretches of official conduct. The ACLU analysis described the ruling as doing grave harm to American democracy by tilting the scales so heavily toward executive power. NYU Law Forum and other academic platforms have published pieces noting that the framework has been criticized by scholars across the ideological spectrum, not just liberals but conservatives who worry about long-term precedent. Even some conservative commentators who generally favor strong presidential authority have warned that without sharper limits, the immunity framework will encourage future presidents from both parties to push the boundaries of lawfulness even further, knowing they have this protective cushion. Constitutional law professors have flooded law review journals with articles calling for the framework to be narrowed in subsequent cases. The pressure from the legal academy feels unprecedented for such a recent Supreme Court decision. This framework is not stable. It sits on shifting ground, and the court will inevitably face cases asking it to revisit, narrow, or overturn aspects of what it decided in 2024. Let's really dig into the full picture here, because understanding the scope of the immunity framework's vulnerability requires examining multiple documented categories of evidence and analysis that all point in the same direction. The original Trump versus United States ruling itself established the 6-3 framework with 3 sharp dissents. The Sotomayor and Jackson dissents form another critical category where 2 sitting justices laid out in precise detail exactly what could go wrong with the majority's approach, predicting scenarios of abuse that now look eerily familiar. The actual application of the framework in 2025 and 2026 represents a third category where federal courts have grappled with applying the immunity tiers to ongoing Trump administration conduct, creating a body of case law that exposes cracks. The mounting scholarly and legal pressure to narrow the ruling forms a fourth category where experts from different ideological backgrounds are uniting in calls for revision. These 4 documented patterns converge on one clear conclusion: the framework is unstable and destined to be tested and likely adjusted in future Supreme Court cases. Let me walk you through the specific language from Chief Justice Roberts' majority opinion, because the technical details reveal why so many see the framework as problematic at its core. Roberts wrote that for core constitutional powers, Congress cannot act on and courts cannot examine the president's actions. Cannot examine, those are the actual words. Federal judges are barred from even looking at the president's actions in those core areas for potential criminality. For presumptive immunity acts, Roberts explained that prosecutors must show that applying a criminal prohibition to that act would pose no dangers of intrusion on the authority and functions of the executive branch. The standard is set so high that any prosecution involving official acts could easily be painted as intruding on executive authority, making it extraordinarily difficult to bring successful cases. The framework was deliberately constructed to make prosecution of official conduct nearly impossible except in the narrowest of private circumstances. Consider what the evidence exclusion ruling represents in practice. The majority held that prosecutors cannot use evidence of official acts to prove charges based on private conduct, even if an act is deemed purely private and therefore prosecutable. Under Tier 3, prosecutors are barred from introducing related official acts as evidence to demonstrate the criminal nature of the private behavior. Lawfare's analysis of the majority opinion put it clearly: the court's evidence ruling effectively immunizes private conduct that is intermingled with official conduct. Translation: even when targeting private criminal conduct, the official pieces of the puzzle cannot be shown to the jury. This restriction protects complex schemes that blend official powers with personal gain. Imagine a president who takes a bribe, a private act, but uses official acts like meetings, pardons, or appointments as part of the scheme. The official act's evidence gets excluded, making the bribery much harder to prove without the full context. This is why Justice Amy Coney Barrett's partial concurrence deserves serious attention. Barrett, one of Trump's own appointees, joined most of the majority, but disagreed strongly with the evidence exclusion part. She wrote that the majority's evidentiary restrictions go too far. Even one of the conservative justices saw problems with how far the protection extended. Her vote was key in the final ruling, and her partial dissent on evidence provides a potential roadmap for future challenges. Subsequent cases involving evidence questions could allow the court to narrow that aspect while keeping other immunity protections intact. That kind of intra-majority disagreement signals the framework is not set in stone. After the immunity ruling, Trump won re-election, took office on January 20, 2025, and began exercising official powers in ways that quickly generated legal challenges, testing the boundaries. Deportation flights to facilities in El Salvador over a federal judge's order invoke Corps Commander-in-Chief authority and test whether immunity fully protects against criminal contempt findings. The pressure applied to the Department of Justice through Attorney General Pam Bondi and Prosecutor Lindsay Halligan to target Comey and James uses DOJ authority as official acts testing if immunity covers vindictive prosecutions. The April 2, 2026 firing of Pam Bondi after those cases collapsed represents an official personnel decision testing whether even firing the Attorney General to manage fallout from controversial actions receives broad immunity. Each scenario is a real-world laboratory experiment of exactly what Sotomayor and Jackson warned could happen when presidential power faces reduced accountability. The Boasberg contempt situation reveals a lot about potential limits. Federal Judge James Boasberg found probable cause to hold the administration in criminal contempt for defying his March 15, 2025 order halting certain deportation flights. The administration argues those flights were core constitutional power exercises and thus absolutely immune. Boasberg's finding implicitly rejected full immunity for defying specific judicial orders. The case is now working its way through the system and will likely produce significant rulings on immunity limits that could narrow the original framework.
Susie Wiles' public admission that the James prosecution was Trump's one retribution establishes vindictive intent on the record. Under normal principles, vindictive prosecution violates constitutional rights regardless of immunity. That admission creates a paper trail that may survive even strong immunity arguments because the framework cannot shield core constitutional violations like selective or retaliatory enforcement of law. Carroll's attorneys or similar parties would likely make parallel arguments in related civil contexts. The evidence rules question remains particularly thorny. While official acts evidence is excluded from private conduct prosecutions, there are limits to that exclusion. Evidence directly relevant to proving private criminality can sometimes still come in, especially if mixed purposes are involved. Each new prosecution attempt generates fresh fact patterns that force courts to draw lines.
Lower federal courts have struggled with these distinctions in cases involving Trump-aligned defendants producing inconsistent rulings across districts. That inconsistency breeds appeals which eventually reach the Supreme Court, creating repeated opportunities to refine or narrow the 2024 decision. Constitutional law scholar Kim Whalen wrote at Just Security that the decision will have repercussions for years to come and not just for Donald Trump. The scholarly criticism spans ideology. Conservative legal scholars who back robust executive power have critiqued the framework for clashing with originalism since the Constitution lacks explicit presidential immunity language. That originalist critique opens the door for conservative justices to narrow the ruling without abandoning their philosophical commitments. Liberal critiques focus on rule of law erosion.